Okay, today I will be reading from the Prisoner's Self-Help Litigation Manual, 4th edition, and I'll be talking about the cruel and unusual punishment standard clause of the Eighth Amendment. The Eighth Amendment, which forbids cruel and unusual punishments, governs the treatment of convicted prisoners. To win an Eighth Amendment case, you must establish both an objective component, the seriousness of the challenged conditions, and a subjective component, the state of mind of the officials who are responsible for them. 1. The objective component, cruel conditions. Prison conditions that are restrictive and even harsh are part of the penalty that criminal offenders pay for their offenses against society. Conditions do not violate the Eighth Amendment unless they amount to the unnecessary and wanton infliction of pain. That phrase can mean several different things in prison litigation. With respect to living conditions, prisoners must demonstrate unquestioned and serious deprivations of basic human needs, or of the minimal civilized measure of life's necessities to establish an Eighth Amendment violation. The Supreme Court has listed as basic human needs food, clothing, shelter, medical care, and reasonable safety, as well as warmth and exercise. The lower courts have also mentioned sanitation and personal hygiene and sleep, and may identify other basic needs in the future. The Supreme Court has held that the temporary 2 years or more deprivation of visiting rights does not deny basic necessities. In our view, the prolonged idleness and deprivation of human contact in some segregation units denies basic human needs for companionship and meaningful activity, but the courts have not yet held so. Even for issues that clearly raise Eighth Amendment concerns, the line between the wanton infliction of pain and conditions that are merely restrictive or harsh has not been clearly drawn. The malicious and sadistic use of force, even without significant injury, is an Eighth Amendment violation, as is other treatment that unjustifiably inflicts pain or injury, or is humiliating or anti-ethical to human dignity. The Supreme Court has also held in connection with cell searches that calculated harassment unrelated to prison needs may constitute cruel and unusual punishment. The court has not mentioned this holding in over 20 years, but has not overruled it, and presumably it is applicable to other forms of harassing conduct besides searches, though lower courts seem reluctant to apply it. Some recent Supreme Court decisions concerning prisoners' Eighth Amendment claims have emphasized physical harm or the risk of it. The court has held that unsafe conditions that pose an unreasonable risk of serious damage to a prisoner's future health may violate the Eighth Amendment, even if the damage has not yet occurred and may not affect every prisoner exposed to the conditions. However, numerous decisions have held that conduct can violate the Eighth Amendment, even if it does not inflict physical injury or cause lasting or permanent harm, though the Prison Litigation Reform Act bars recovery of damages for mental or emotional injury in the absence of physical injury. Even conditions that are physically or mentally harmful or that deprive prisoners of basic needs may not violate the Eighth Amendment if they serve a legitimate correctional purpose. Thus, one court has held that depriving close management prisoners of their 2 hours weekly outdoor recreation when they committed serious and dangerous misconduct did not violate the Eighth Amendment, even if it inflicted pain in light of its penological justification. Prison officials are entitled to deference in their decisions concerning order and security. However, there are limits. One court has held that it is unconstitutional to inflict serious psychological pain on inmates to serve minor correctional concerns, routine and automatic security concerns, or pragmatic interests of lesser significance. The Eighth Amendment standard draws its meaning from the evolving standards of decency that mark the progress of a maturing society. In cases involving risk to health or safety, courts must assess whether society considers the risk, that the prisoner complains of to be so grave that it violates contemporary standards of decency to expose anyone unwillingly to such a risk. In other words, the prisoner must show that the risk of which he complains is not one that today's society chooses to tolerate. However, judges are supposed to rely as much as possible on objective factors, such as statutes, and not on their personal opinions about standards of decency. Some courts have held that state or federal prison regulations and health requirements, as well as statutes, are evidence of current standards of decency. However, statutes and regulations are only one factor in Eighth Amendment analysis, and violations of them do not always violate the Eighth Amendment. The converse is also true. Conditions may violate the Eighth Amendment even if they do not violate state laws. Similarly, professional standards or expert opinions about how prisons should be run do not determine what is acceptable under the Eighth Amendment, though they may assist the court in understanding the issues before it. Several decisions have noted that accreditation by organizations such as the American Correctional Association or the National Commission on Correctional Health Care does not establish that a prison or prison system is operating in a constitutional manner. Some courts have held that risks of a type that is commonplace outside prisons do not violate the Eighth Amendment. We think this approach is wrong. After all, violent assault and exposure to environmental tobacco smoke, which the Supreme Court has said present Eighth Amendment concerns, also occur in civilian society. In Eighth Amendment cases, courts inquire whether conditions alone or in combination deprive inmates of the minimal civilized measure of life's necessities. Under this totality of the circumstances approach, merely unpleasant conditions do not automatically become unconstitutional when you add them together. Rather, conditions must have a mutually enforcing effect that produces the deprivation of a single, identifiable human need in order to become unconstitutional in combination. Examples of this mutually enforcing effect include a low cell temperature at night combined with the failure to issue blankets, or restrictions on outdoor exercise combined with long lock-in times. Similarly, courts are more likely to find crowding unconstitutional if it occurs in combination with long lock-in times or contributes to other dangerous or deteriorated conditions. Prison officials cannot trade off unconstitutional conditions under this theory. If one condition is cruel and unusual, the fact that other conditions are better will not save prison officials from Eighth Amendment liability. Often the length of the time prisoners are subjected to an unpleasant condition plays an important part in determining whether it is cruel and unusual. But especially degrading or abusive conditions are unconstitutional, even if imposed for short periods of time. The Supreme Court has held in criminal cases that punishments must not be grossly disproportionate to the crime. This principle has played little part in Eighth Amendment analysis of prison conditions. The subjective component, deliberate indifference. In Eighth Amendment conditions cases, the plaintiff must prove that the defendants acted with deliberate indifference. The deliberate indifference standard does not apply to cases involving the use of force. In those cases, the plaintiff must show that the defendants acted maliciously and sadistically. Deliberate indifference in Eighth Amendment cases falls somewhere between mere negligence, carelessness, and actual malice, which is the intent to cause harm. That is, it amounts to recklessness. Sometimes deliberate indifference is shown by evidence of prison personnel's bad motives or attitudes. However, the Supreme Court has held that a prison official can be found reckless or deliberately indifferent if the official knows of and or regards an excessive risk to inmate health or safety. This is the same standard of recklessness that is used in criminal law, and it is sometimes called the subjective approach to recklessness. If prison officials know that conditions are objectively cruel and fail to act to remedy them, they are deliberately indifferent. Prison officials are, however, allowed to impose severe hardships on prisoners for legitimate penological purposes, such as maintaining security and the discipline, without being found deliberately indifferent. It is not enough in an Eighth Amendment case to show that the definition should have known of a risk or of cruel conditions, and other cases saying that are no longer good law. However, the fact that a condition or risk was obvious is circumstantial evidence that will permit a judge or jury to conclude that a defendant did know about it, even if there is no direct evidence about what the defendant knew. Therefore, if you can show that officials disregarded a risk that was obvious, the court should not grant summary judgment against you, and you should have the right to a trial. Though you will not necessarily win in the end, since the court or jury may not find the defendants drew the inference that you were at risk, or even that it was obvious. Other kinds of facts may also be circumstantial evidence that the defendant had actual knowledge of a risk. Purposely avoiding knowledge may also amount to deliberate indifference. A defendant need not know the precise nature of the risk to be found deliberately indifferent, as long as she knows that a serious risk exists. A defendant also need not have knowledge of a specific risk to a specific individual from a specific source. For example, in an inmate assault case, it does not matter whether the risk comes from a single source or multiple sources, any more than it matters whether a prisoner faces an excessive risk of attack for reasons personal to him, or because all prisoners in his situation face such a risk. An official who has knowledge of a serious risk or a cruel condition must take reasonable measures to abate it. Prison officials who respond reasonably to the risk are not deliberately indifferent, even if the harm ultimately was not averted. However, they may be liable if their actions are not adequate given the known risk, or if they give inconsequential logistical concerns that might be no more than matters of convenience, higher priority than prisoners' basic human needs. Some courts have said that prison officials cannot be found deliberately indifferent unless they possessed actual knowledge of impending harm easily preventable, or that they exposed the plaintiff to a risk because of, rather than in spite of, the risk to him. This is wrong. While actual knowledge must be shown under Farmer, the other items need not. You can sue under the 8th Amendment for harm that is not impending. Farmer said that serious damage to prisoners' future health is actionable. The harm does not have to be easily preventable. Farmer holds that prison officials must do what is reasonable, not what is easy. In addition, Farmer specifically said that it is enough that the official acted or failed to act despite his knowledge of a substantial risk of serious harm, and did not require proof that the official acted because of the risk. In deliberate indifference cases, especially individual damages cases, you must try to identify exactly who was deliberately indifferent. In some cases, your claim may be against line staff who do not do their jobs. In others, it may be against supervisors for knowing acquiescence in the unconstitutional behavior of subordinates, persistently violating a statutory duty to inquire about such behavior and to be responsible for preventing it, failure to train or supervise, or an official acquiescence in the continued existence of prison conditions which themselves are so injurious to prisoners that they amount to a constitutional violation. In others, supervisors of cities or county governments may be found to have policies amounting to deliberate indifference, or prisoners challenge institutional policies, practices, inadequate facilities, etc., rather than individual misconduct of prison staff. Courts have often held that deliberate indifference can be shown by repeated examples of negligent acts which disclose a pattern of conduct, or by showing systematic or gross deficiencies in staffing, facilities, equipment, or procedures, regardless of prison officials' motives. In cases where prisoners seek injunctions, which are considered to be official capacity rather than individual capacity cases, the court may find deliberate indifference even if particular officials are well motivated as individuals. In such cases, the focus is on the institution's historical indifference rather than the state of knowledge and the response of a particular individual. In an injunctive case, the actual knowledge that is necessary to support a grant of relief may be provided by the judicial proceeding itself. In pleading an Eighth Amendment deliberate indifference claim, you should identify the right or risk to which the defendants were indifferent. With respect to medical care, the Supreme Court has held that prisoners must show deliberate indifference to serious medical needs. In other kinds of cases, you should use a similar phrase, identifying the particular human need you have been deprived of, using terms used by earlier Eighth Amendment cases. For example, if you were locked in a cell without a working toilet, you would refer to deliberate indifference to the plaintiff's need for reasonably adequate sanitation, or for the needs for basic elements of hygiene. If officials fail to knowingly protect you from assault, you would refer to deliberate indifference to the plaintiff's need for safety. Other legal limits on prison conditions. The Eighth Amendment does not apply to pretrial detainees, who cannot be punished at all, or at least in theory, under the Due Process Clause. However, conditions or restrictions are not considered punishment if they are reasonably related to a legitimate goal and not arbitrary or purposeless. In practice, there is not much difference between the outcomes of convicts and detainees' challenges to conditions of confinement, and we cite due process and Eighth Amendment cases more or less interchangeably in this chapter. The rights of detainees are discussed in more detail in Chapter 6. Many state constitutions have clauses relevant to prison conditions. These clauses may provide greater protection than the federal cruel and unusual clause or the federal due process clause. Even if the state constitutional provision is worded similarly to the federal provision, a state court could interpret the state constitution as providing more rights for prisoners. So far, most courts have either rejected that view or have avoided the question. State statutes and regulations may also provide more rights than the federal constitution, and you may be able to enforce these in state court. Federal statutes and regulations may also be enforceable in federal court through the Administrative Procedures Act and otherwise. Tort law may be enforced against state and local governments or prison personnel and against the federal government through the Federal Tort Claims Act. There are also international laws and treaties that are intended to protect prisoners. These are beyond the scope of this manual, chiefly because they do not in practice provide any additional protections for American prisoners. Though the United States has ratified the International Covenant on Civil and Political Rights and the Convention Against Torture and Other Cruel, Inhumane, or Degrading Treatment or Punishment, it has done so with reservations, interpreting their language to go no further than American constitutional law. One commenter has said, "These reservations present perhaps the greatest obstacle to prisoners' rights in the United States." So you have deliberate indifference, like if you got a medical need or whatever and they're not doing it, it's deliberate indifference. And deliberate indifference is that the staff, the prison official, whoever, knew of a substantial risk of serious harm and they failed to respond reasonably. And if you could prove that, that you had they was deliberately indifferent to medical need, you know what I'm saying, they refused your treatment, then they knew of a substantial risk of serious harm to you, and they failed to respond reasonably as long as it's within the constitutional standard. Say you was going to get your tonsils taken out prior to going to prison. You went to prison and you got a free world specialist doctor's note saying that you got chronic tonsillitis. You're supposed to get your tonsils taken out. All right. Well, prison refused to do it. You got an expert witness and a specialist that specializes in ear, nose, and throat from the society, and now you're in prison. They refuse to do it. Well, and he says that you got chronic tonsillitis. You need your tonsils taken out. You're in pain, especially if you're in pain, for instance. Then you got a valid deliberate indifference claim. And all you got to do is show and prove that you had this claim prior to prison, you was in prison, you knew this happened, you have your expert witness, and that they knew of a substantial risk of serious injury, and they failed to respond reasonably. They were deliberate and different to your serious medical needs, your overall health and safety. That's deliberate indifference. And on excessive force claims, what you got to prove is that they was malicious and sadistic for the sole purpose of causing you harm, and they caused you harm. And like I say once again, the only way that you can get damages, money or rewards for the mental, emotional, abuse is if you suffered a physical, pain, injury. You know what I'm saying? Now, however, I look at it like this. I study law, and I'm all about neurology, psychology, psychiatry, things of that nature as well. Well, here's the thing, in my opinion, which, I like to argue this sometime in court. And if you take a psychiatric drug, for instance, okay, you got pheromones, hormones, you got all that stuff, in oxytocins and all that in your brain, okay? So with that being said, now it's your brain that controls every part of your body. You know what I'm saying? Like, unconsciously at times, you know what I'm saying? So with that being said, if your brain's not well, you're serving PTSD, the police beat the hell out of you, almost killed you, and now you're traumatized and you're, captive, you know what I'm saying? Being held against your will, kidnapped, abducted, you know what I'm saying? Then it's like, yeah, they beat you up, they almost killed you, you know what I'm saying? It's like, you got PTSD. Now, you have flashbacks and all this other stuff. Well, you got a constitutional claim because they almost killed you, they beat you up. Okay, so that's where you get paid for the mental. But what if it's just like mental abuse? If you got police coming around harassing you all day, every day, coming, turning your lights on, banging on your door, waking you up, sleep depriving you, okay? Well, the brain is physiological. You take these psychiatric drugs and everything that control these endorphins and oxytocins, etc., in your brain. So if you are chemically imbalanced due to the stress, the PTSD, whatever, then on a physiological, biological level, deep down inside, on a minuscule level, you may not see it. That's what messes with your head, causes you depressed, anxiety, and all of that. You know what I'm saying? Which are, to some degree, normal, human functions, but it's still on a physiological level. So if you are being, like, traumatized, terrorized, harassed by police, for instance, it's like, you may not see that pain, but when you look up the definition of pain in the dictionary, pain is pain, regardless of whether it's physical and you can show a physical injury, or if it's emotional, deep down inside mental, you know what I'm saying? And you can't see those little bitty, small, minuscule chemicals in your brain. I mean, period. That's the way I look at it. So when it's all said and done, that should be wrong. And I mean, I got enough stuff I'm working on right now to really eventually maybe get into that. But yeah. So but that's what I wanted to break down to y'all today for a little bit. And I have more lives about law. I have more lives on psychology and things of that nature in the future. But I have my life too, so this is like a pastime. I want to try to educate and help others, because I feel like in life, especially in America, you know what I'm saying, the USA, you need to know that law, man, in order to, combat the police. Because I'm going to tell you this. Police are law enforcers. They're not lawyers. You see what I'm saying? So their knowledge of the law is limited to, and then they violate the law all the time, but then they ain't going around and policing themselves. So I want to be able to arm the people with knowledge to be able to, whatever it is, help you legally if you ever find yourself in a jam or dealing with law enforcement or the legal system. Also, if you're going through like some mentally challenging times in your life, you know what I'm saying, I would hope that ultimately, you know what I'm saying, it's up to you. You got to have that willpower to rise up, you know what I'm saying, mentally, you know what I'm saying, but it always helps if you have positive support, or if you have resources and people that's on a positive, inspirational level that can motivate you, even if, you don't know them, you know what I'm saying? Like this, but I'm going to get off here, though. But yeah, that's what I want to say for y'all today, all right?